Walk into Roman law where debt, property, and damage meet, and the first thing you see is not an abstract theory. You see things. Tools stand on an estate because payment has not yet been made. Herds and slaves on the land are tied to a promise that still waits for satisfaction. Grain sits in storage with a loan hanging over it. A thing has been delivered and used before the neatest form of title has caught up with it. A slave, an ox, a beam, or a useful object has been killed, broken, burned, or spoiled, and someone now wants the loss turned into money. That is the world of this episode. The questions are simple to ask and hard to answer. Who owns the thing? Who merely holds it? How does title move from one person to another? How can property stand behind debt without always leaving the debtor's hands? What is the difference between a pledge and a transfer of ownership? When damage happens, what exactly has to be paid for? And how did Roman law decide whether loss became a legally measurable claim? One caution must come first. Much of our cleanest language for Roman ownership, pledge, and wrongful damage comes from later jurists, from Gaius, and from later compilations that arranged older legal materials in a clearer form than daily life would have had. For pledge, the evidence is bluntest of all. The period from 300 to 100 BC is one of the darkest stretches in Roman legal history for Pignus and hypotheca. The mature vocabulary is useful, and it cannot be treated as a perfect voice from the Middle Republic. The safest way to tell the episode is to hold practice and later explanation together. Practice gives us agricultural clauses, business tablets, grain security, and the rough pressure of debt. Later jurists give us the sharper categories: ownership and possession, formal transfer and delivery, usucapion and pledge, Aquilian damage and compensation. The order is often later than the practice. The practice is still real. Roman law kept learning how to turn control, debt, and damage into claims. Begin with the most basic question: who owns the thing? Ownership was the strongest legal claim to a thing, and Roman law cared deeply about possession too. Possession meant holding or controlling a thing in a way the law might recognize. It was not the same as ownership, for a thief can physically hold what he does not own, and a lawful owner can be parted from what belongs to him. But possession mattered, because proof of ownership could be difficult, and because holding a thing under the right conditions could become, in time, a road toward ownership. The law distinguished legal possession that could support usucapion and mere custody. The distinction matters because the hand on the object did not always mean the same thing. A borrower, a tenant, a thief, a purchaser, and a man holding goods for someone else might all physically control property. The law did not treat every kind of control as equal. Roman property law kept asking what kind of hand was on the thing and why it was there. Gaius gives the clearest later explanation of a split in ownership that can feel strange at first hearing. He describes Quiritary ownership, the old full civil law ownership of a Roman citizen, and bonitary holding, where someone held the thing in his goods, though full formal title had not yet caught up. The usual example involves a res mancipi, one of the weightier things that old civil law treated with special formality. If such a thing was merely delivered, rather than transferred by the proper civil form, practical control could move to the recipient while Quiritary ownership stayed with the transferor, until usucapion completed the title. The terms can sound forbidding, so put them plainly. Res mancipi were the old high-value things of the farm: land, slaves, beasts of burden, and certain rural rights. Quiritary ownership was the strict civil title. Bonitary holding meant the recipient had the thing in a protected practical sense, though the old formal title had not fully moved. Usucapion was the process by which possession over time could ripen into ownership. Gaius is not writing a fresh republican diary, he is giving a later juristic explanation. But the explanation shows that Roman ownership was sometimes layered, not a single clean switch. The old formal route was Mancipatio, the solemn transfer for res mancipi. The procedure was concrete: the parties, 5 Roman citizen witnesses, a man holding the scales, bronze, and fixed words. Mancipatio stood as the primary civil law mode for transferring res mancipi through much of Roman legal history. If the form was performed correctly, ownership passed at once and without condition. It was public, memorable, and hard to unsay afterward. That form made sense in an older farming world, where the most important property needed heavy ceremony, but ordinary life needed a more flexible route, and that is where Traditio enters. Traditio means delivery, and Roman law did not treat bare handover as enough by itself. Delivery was a causal transaction. There had to be a lawful reason behind it: sale, gift, exchange, inheritance, or another recognized cause. The law asked not only whether the thing changed hands, but why it changed hands. That question kept the transaction from becoming empty movement. If I hand you an object, the law still wants to know whether I sold it, gave it, lent it, entrusted it, or transferred it for some other lawful reason. The physical act is visible. The legal cause says what the act means. Roman law could be practical without being careless. It wanted the thing to move, and it wanted the movement to stand on legally intelligible ground. Time could also solve a problem of title. Usucapio, acquisition by use over time, allowed possession to ripen into ownership under strict conditions. The mature doctrine required possession, continuity, the passage of time, good faith, a proper lawful cause, and a thing capable of being usucapted. The old periods were 1 year for movable things, 2 for land and houses. Stolen property, as a rule, could not take this path. The point is not a checklist to memorize. The point is that Roman law could settle uncertainty in the end, by letting honest, continuous, lawful possession become title. Once ownership, possession, transfer, and time are in view, secured credit becomes easier to understand. Credit makes a problem of trust. The creditor has given money, goods, or value now, while repayment lies in the future. A pledge gives the creditor something more than the debtor's word. It ties a thing or the value of a thing to the debt. If the debt fails, the creditor has recourse. The early evidence is rough, and it is concrete. In Cato's agricultural forms, everything brought onto an estate for the work could stand as pledge until payment or satisfaction was given. If a pledged item was removed from the land, the clause could provide that it belonged to the owner. Another template tied the herds and slaves present on the land to the arrangement until money was paid or other satisfaction made. These are transactional practices with formative force, not a finished later doctrine. The difference matters. Cato's clauses show working property tied to payment. They do not give the whole later law of pledge. They show a landowner, workers, animals, equipment, and payment bound together in a practical arrangement. The legal pressure is easy to see. If the debtor can simply remove the pledged things, the creditor stands exposed. If every pledged thing must be seized at once, productive life may stop. Roman law had to learn how to make property answer for debt, without destroying the very activity that might pay the debt. The Sulpicii archive gives a later and sharper documentary example. In one 1st century AD text from Puteoli, a borrower declared that if 20,000 sesterces were not paid by the Ides of May, the creditor could sell the pledged grain at auction. If the grain sold for more than the debt, the surplus returned to the debtor. If it sold for less, the debtor still owed the balance. The clause is worth holding in the mind. The grain is not simply swallowed by the creditor. It is treated as value answering for a measured obligation. That is a legal advance. The creditor is protected up to the debt. The debtor keeps the excess if the collateral sells well. The debtor still owes the deficit if the collateral falls short. The pledged thing becomes a financial answer, not a crude prize. Property stands behind credit, and enforcement becomes a calculation. Later jurists distinguished Pignus and hypotheca. Pignus was possessory pledge. The creditor received possession of the thing as security. Hypotheca was non-possessory security. The thing was burdened for the debt while possession stayed where it was. The distinction is later and cleaner than the Republican evidence, and it is very useful. It shows 2 answers to the same problem. Does the creditor need to hold the thing, or can the thing remain with the debtor and still answer for the debt? Non-possessory security mattered because useful property often needed to keep working. Animals could remain on the land, tools could remain in the workshop, grain could remain inside a commercial process until enforcement became necessary. If every secured asset had to be removed from use, credit could damage production. If the law could burden property without taking it away at once, debt could be secured while economic life continued. That flexibility did not blur the line between security and ownership. Even if later hypotheca could arise by agreement alone, Roman ownership itself was not transferred by naked pact. Ownership required the right legal structure, delivery plus a valid cause, or the formal civil act where that was needed. Security law could grow more flexible than ownership law. It did not make ownership float from person to person on promise alone. Fiducia helps show the difference. In fiducia, ownership itself passed to the creditor for security and had to be returned once the debt was discharged. In Pignus, the creditor's strength lay in the security interest and the actions tied to it, not in outright ownership of the collateral. Both involved property and trust. They did not do the same work. Roman law kept separating questions that might otherwise collapse together. Has ownership passed? Has possession passed? Has the thing merely been burdened? What must be restored when the debt is paid? Now turn from debt to damage. If secured credit asks how a thing can answer for a future debt, wrongful damage asks how a harmed thing becomes compensation. Earlier Roman law had scattered remedies and fixed penalties for different kinds of injury. The Lex Aquilia became the decisive reform for wrongful damage to property, most plausibly dated to 287 BC. It did not create a modern law of all harm. It gave Roman law a central way to price certain wrongful injuries to property. The first chapter was narrow and powerful. It covered the wrongful killing of another person's slave, servant girl, or certain four-footed animals of the cattle class. The defendant had to pay the highest value the property had reached in the preceding year. The rule has a penal edge. It does not merely ask what the slave or animal was worth at the moment of death. If the highest value in the year was greater, that higher figure governed. The wrongdoer could pay more than a simple replacement price. Why the highest value? Because the law was not only measuring loss, it was giving the rule force. A slave or an animal might be worth different amounts at different moments by age, training, health, pregnancy, market conditions, or expected use. The year's highest value prevented the wrongdoer from profiting by a low moment in the value of what he destroyed. It made wrongful destruction answer to a sterner measure. The third chapter was broader and less certain. Ulpian's later wording speaks of wrongful burning, breaking, or spoiling of other property, and a valuation over 30 days. The exact original wording cannot be recovered with confidence, because later interpretation lies thick over the statute. Even one key verb was widened over time, from a narrower sense towards spoiling or corrupting more generally. This is a good place to remember the opening caution. We often see republican law through later juristic glass. Even under that caution, the legal movement is clear. Damage law was learning to translate physical harm into value. The law had to decide what counted as wrongful harm, who could sue, how value should be measured, and how far the financial consequences should run. By the classical period, consequential loss could matter. The owner could sometimes recover more than the bare momentary price, where the legally protected financial interest ran wider. But sentimental grief was not compensated. Roman law valued the protected financial interest, not personal attachment to the damaged thing. Fault stood at the center. In the Aquilian setting, iniuria meant wrongful fault, not every unhappy outcome. The standards were those of the diligent person and the bonus paterfamilias, the careful head of a household. Inexperience could count as fault when someone took on a task requiring skill or control. The mule driver example makes it plain. If a man undertakes work that needs strength or skill and lacks what the work requires, the lack itself can be blameworthy. Roman law asks what a competent person in that position should have foreseen and prevented. Causation mattered too. If the victim's own conduct was treated as the cause of the harm, the claim could fail. At the same time, the law could take damaged property as it found it. A sickly slave who died from a light blow did not necessarily save the wrongdoer, simply because a stronger slave might have lived. The question was not whether the damaged thing had been ideal. The question was whether the defendant's wrongful act caused legally relevant loss. The older action began also with a narrower idea of direct physical damage, sometimes expressed as harm from body to body. That was too narrow for every practical wrong Roman law eventually needed to reach. Praetorian and juristic development extended the protection through supplementary actions, which allowed relief in cases near enough to the statute's purpose even when the old words did not fit. Roman law did this often. It preserved an old form, then built roots around it when life pressed harder than the words could bear. The action had teeth. If a defendant disputed liability and lost, the condemnation could be doubled. The original action belonged to owners, but the later supplementary actions could protect others with serious financial interests, usufructuaries and bona fide possessors among them. A usufructuary was a person entitled to use and take the benefit of property owned by another. A bona fide possessor was a good faith holder. These people were not the owner. Their economic interest could become too real for the law to ignore. By now the shared pattern is visible. Roman property law kept refusing to stop at the surface of the thing. A man might hold without owning. A man might own by strict civil title while another held in a protected practical position. A thing might move by formal ceremony, by delivery with lawful cause, or by possession ripening through time. A thing might be transferred in ownership for security, pledged with possession, or burdened without possession passing. A damaged thing might be valued by the year's highest price, by a 30-day measure, or by a wider protected financial interest. That may sound technical. The human pressure is ordinary. A creditor wants the debt paid. A debtor wants to keep using the tools that might make payment possible. A buyer wants the thing he has received to become securely his. An owner wants damage answered in money. A man who holds property in good faith wants the law to recognize that his loss is real. Roman law did not answer all these people with one theory. It built roots. Those roots were sometimes harsh. Slaves appear in this field as property, as collateral, and as compensable loss, which is exactly why a later episode must treat slavery directly rather than leave it sitting silently inside the categories of property. Debt security could protect creditors more than debtors. Damage valuation protected financial interest, not human grief. Formal title could favor the party who knew the correct legal form. The law made claims more legible. Legibility was not equality. Still, the achievement is great. Roman law turned material uncertainty into legal questions that could be argued. Who owns? Who possesses? Was there a valid cause for the delivery? Has time cured the defect in title? What stands behind the debt? Has ownership passed or only security? Was the thing wrongfully damaged? What value should answer for the loss? These questions made the world more governable because they separated problems that ordinary anger would fuse together. So credit, damage, and property before Roman law are not separate shelves. There are three ways of asking how things become claims. Debt turns property into security. Transfer turns possession, form, cause, and time into ownership. Damage turns injury into valuation, fault, and compensation. The mature language often comes from later jurists, and the early evidence can be thin, for pledge above all. But the Roman habit is unmistakable. The law kept reaching into material life and asking what could be owned, what could be held, what could secure a debt, what could be harmed, and what another person now owed because of it.